Greetings, students. Hi, this is Satyaki Chakraborty from Indraprastha Law College, Greater Noida, and today's topic for the day is development of criminal law and law of evidence in India. And the subject is legal and constitutional history, and this is particularly meant for BL-LLB third sem students. Students, we have already discussed the development of the judicial grounds of the Indian legal system and the history behind it. We have already discussed codification and the commission too, and the development of criminal law, contract law, evidence act, and various forms of other laws that has been developed with time, with all the codification that happened in 1833 and the various 5 commissions which were created in several tenure of years. Now let us see the development of criminal law. According to the Codification of Substantive Criminal Law, or according to the Charter Act of 1833, India's first law commission in 1834 recommended drafting of the Indian Penal Code. Lord Macaulay was the chairman of the law commission who spearheaded its drafting. The code was basically a comprehensive enactment describing all major crimes in existence at that very period of time. So, पहला कमीशन 1833 में हुआ था और कोडिफिकेशन 1833 पे हुआ था और फर्स्ट लॉ कमीशन बना था 1834 और वही रिकमेंड किया था द ड्राफ्टिंग ऑफ द आईपीसी. लॉर्ड मकाउले उसी ज़माने पे ही वॉज द चेयरमैन ऑफ द लॉ हु स्पीयरहेडेड द होल ड्राफ्टिंग एंड द कोड वॉज बेसिकली द इनैक्टमेंट्स ऑफ द मेजर क्राइम्स. जो क्राइम होते थे उस ज़माने पे उसके तहत जो लॉ फॉर्म हुआ था वो कोड ऑफ कंडक्ट को उसी टाइम पे इनैक्ट किया गया था. Despite several revisions over almost 30 years, the law did not come into force until 1860. It was only after the rebellion of 1857 that the British decided to implement it. IPC has been several amendments since it first came into existence. Although it largely relied on British laws and practices, many of its provisions are still the same. So, there has been several amendments over the years since its formation, since it came into existence. And although there has been many changes and there had been many developments over the years, but still the main framework or the main characteristic and the features completely rely on the British law and practices, where many provisions are still the same. So let us take a peek at the codification of the substantive criminal law. So हम लोग ये देखते हैं कि काफ़ी चेंजेस रहा है. विद टाइम देयर हैज़ बीन सेवरल चेंजेस दैट हैज़ बीन ब्रॉट अबाउट, लेकिन जो मेन फ्रेमवर्क रहा है वो ब्रिटिश प्रोविजन या ब्रिटिश लॉ पे जो था वही अभी तक हम लोग फॉलो करते हैं. लेकिन फिर भी विद चेंजिंग टाइम्स काफ़ी इम्प्लीमेंटेशंस हुआ है, काफ़ी अमेंडमेंट्स हुआ है, काफ़ी चेंजेस आए हैं और उनको भी इंट्रोड्यूस किया गया है. लेकिन जो बेसिक फ्रेमवर्क था वो ब्रिटिश प्रोविजंस, ब्रिटिश लॉ ही रहा है. Although the British had enacted a criminal procedure code for India in 1862, modern procedural codes came much later. The Code of 1862 was amended and replaced many times later to make procedural laws modern. After independence, the Law Commission made many recommendations to update CRPC. Some of these changes were the abolition of jury trials. The most important reason for this change was to make the Criminal Procedure Code quick and effective. CRPC was finally enacted again by the Parliament in 1873 and it has been amended many times since then. So these are the basic information regarding the development of criminal law in India. Alright, where several changes have been brought about with changing times, because of course we need to tune according to the changing times with the changing situations and the circumstances. So what we tend to see is that, for example, some of the changes are brought about, for example, the abolition of the jury trials. And one of the most important reasons for this change was to make criminal procedure more quick, more effective, and so that it can be easily and uniformly implemented. Now, Let us take a peek at the development of the Evidence Act. For example, let us look at the British period. What has the British period had to offer with the development of Evidence Act? The Evidence Act was originally passed by the British Parliament in 1872. It contains a set of rules and regulation which governs the admissibility of any evidence in the courts of law. The concept of admissibility of any evidence in courts of law was totally changed in British India after the introduction of Evidence Act. The Evidence Act of 1872 is mainly based upon the work by Sir James Fitzgerald Stephen. He is also known as the founding father of this act. Indian Evidence Act and basic introduction. The word evidence is derived from the Latin word evidere, which means to show clear or to prove. So, Indian Evidence Act or the word evidence का मतलब एक लैटिन वर्ड है जिनकी मतलब है समथिंग टू क्लियर और समथिंग टू प्रूफ, एक एविडेंस जो प्रूफ करता है, जो डाउट को क्लियर करता है. द इंडियन एविडेंस एक्ट इज लेक्स फॉरी लॉ विच मीन्स लॉ ऑफ द प्लेस वेयर प्रोसीडिंग इज बीइंग टेकन. The Indian Evidence Act is the Act number 1 of 1872. The whole act comprises of total 167 sections and 11 chapters. The Evidence Act came into force from 1st September 1872. All the definitions, methods related to evidence and how the law of evidence is consolidated is included in this act itself. So these are the basic information that you should know. Students, when you study in details about the Evidence Act and criminal law and IPC, of course, you will tend to understand what the law is all about, how the law was amended and the changes brought about and what the law talks about. But here, just know the basic differences, because here what we are studying right now is the legal and the constitutional history of India. And this tends to give you the basic information of how the Evidence Act was formed or how the criminal law was developed, how it came into being with the process of codification and commission. So, it is applicable to all over India except the state of Jammu and Kashmir. This act is not applicable to Army law, Naval law, Disciplinary Act and all the affidavits which are presented in the front of the officers of the courts. Indian Evidence Act usage. India, the law of evidence is a very important part of both the system, that is civil and criminal. The enactment of this act is known as the path-breaking judicial measure introduced in India, which changed the entire system of Indian judiciary. The whole judicial system gets changed after the enactment of this act, because there was no codified rule or set up rules and regulations for taking evidence. This act is based on the English law of evidence. It is not exhaustive in nature. One of the example that it is not exhaustive in nature was in 2010 when Information Technology Act came into existence. Indian Evidence Act gets amended with all the electronic records. So students, these are the basic idea or the basic gist of a definition regarding the Indian Criminal Law and Indian Evidence Act, how it came into being, what is its basic features, what are the basic information regarding the development of the Indian Criminal Law and the Indian Evidence Act, और उनका significance क्या रहा है. So this is all about the Indian evidence and the Indian criminal law of India. Thank you, class.